to welcome everyone here. My name is Anna Proskurina. I work at Democracy International as a project and communication officer. And this webinar is part of our series of webinars. So it is part of the series organized by Direct Democracy Navigator. This is a database of direct democracy tools around the world. And of course, we have the, so to say, scientific direction of the work where we, update the legal designs in the database itself, but also, of course, we want to share our direct democracy passion and knowledge with other scientists, and at the same time bring this academic knowledge to a wider community of activists, democracy enthusiasts, any active citizens. And this is why we are doing this webinar now. This webinar is the third one in the series, and we are already working on the next one, the fourth one. And I think you are the first ones to know that it will be the webinar dedicated to direct democracy in small island states. In a minute, I will send you the link to upcoming webinar, to previous webinars, and to Navigator itself in the chat. And those who are not joining for the first time, but joining us more often, know that I'm usually your moderator, but today I'm very happy to pass this to my colleague Chandresa, who will be moderating this webinar. Thank you, Chandresa. Sure. Of course, I will be here and look forward to hearing from our speakers. Thank you very much.
Hello, everyone. As Anya introduced me, I am Chandresa. I'm a volunteering intern in the fundraising department right now at Democracy International. I'm so happy to be here with you today. Thank you for joining us and for your contribution, especially to the speakers. Before going into the format of the webinar, I just want to mention that we have two consultations happening within Democracy International. One of them is the future of the European democracy, and the second one is a stronger EU for the world. And Anya, in a couple of minutes, will send the links to the both consultation, and you can give an opinion or your thoughts. It's very nice for us to hear your voices, and not just for us, but for European democracy in general. So please, if you have time, you can share your thoughts. The format of the webinar, it's going to last 1.5 hours. And for the first part, we have 3 speakers for this webinar. And after this, the speaking time, which is 15 minutes, we have a Q&A session. And in this Q&A session, you are going to be unmuted and ask questions. However, if you want, you can ask your question on the chat. But in any case, you can ask your question by raising your hands. Is below. It's react, and then raise your hand and you can ask a question. As Anya said, the webinar will be recorded, and I hope it's okay with all of you and also with people who are joining right now. Today we have a range of diverse speakers. In this webinar, Navigating Rejective Referendums, we have cases of the Netherlands, Italy, and Ecuador. We are going to start with the concept of rejective referendums and its specific use in 3 different contexts: challenges, the opportunities, and most importantly, the implementation of this the referendums in this context. And today with us, we have sorry for my pronunciation, Thijs Vos, a political scientist and doctoral researcher at Leiden University, Professor Claudio Martinelli from the University of Milano Bicocca for the Italian case. And we have Professor Carlos Larrea Maldonado from the University of Andina Simon Bolivar for the Ecuador case. Again, thank you for joining, and without losing any time, we can directly go to the first presentation, which is for the Netherlands case. And yes, please.
Thanks a lot, Chandresa, for this opportunity. I'm going to get the slides. A single moment, please. Yes. Now the slide will be visible for everybody. Thanks again for the opportunity to discuss the experiences, or maybe I should say inexperiences, with the rejective referendum in the Netherlands. The Netherlands is quite a notorious case when it comes to discussing direct democracy and the rejective referendum in particular. Perhaps if you think of the Netherlands and direct democracy, you might remember that in 2018, the Dutch government became quite infamous for abolishing the rejective referendum law that we had in the Netherlands. In fact, it's as far as I know, the only democracy which ever abolished the rejective referendum after introducing it. And it is also notorious for the fact that the referendum in the Netherlands is a bit like a phoenix. Even when it is abolished, soon after discussions again start to reintroducing referendums. This is also happening today, quite literally, in fact. Today, the Dutch Parliament has been discussing a constitutional amendment to introduce the binding rejective referendum in the Netherlands. We still have to see how that will play out. In the presentation of today, I will be discussing, on one hand, giving an overview of the historical development of the rejective referendum and the attempts to introduce it and abolish it, as well as the experiences we had in the brief periods that the Netherlands had a rejective referendum. Ironically enough, the Netherlands is perhaps one of the first countries which did have a referendum in world history. The first referendum in the Netherlands actually already happened in the end of the 18th century, shortly after the Netherlands was liberated or occupied, depending on your perspective, by the French armies after the French Revolution. And the new revolutionary government tried to introduce a new modern constitution, and it wanted it to be passed into a referendum. And in this referendum, we see something that's happened quite a lot in the Netherlands. The outcome of this first referendum was not really to the liking of the government of the day. The constitution was rejected by a majority in the referendum, and the constitution was basically still, even though there was a negative result in the referendum. And this early experience with the referendum actually only lasted quite shortly. After the revolutions passed in the early 19th century, the Dutch Republic was replaced by a constitutional monarchy in which representative democracy was the only game in town. In fact, the constitution of that time did not even allow for consultative referendums because of the constitution of that time, in fact, stipulated that it was not allowed to consult the people on issues that are discussed in parliament. It was only until the 60s of the previous century that demands for democratization re-emerged. This was a time in which there were a lot of protests and emancipation movements, and people wished to have more influence on the political decision making. This also transformed the Dutch political party system. New parties emerged, pro-democracy parties emerged, whereas the religious conservative parties that have always been against referendums lost their majority for the first time. So we had quite a lot of polarization in the Netherlands in this time, which on the one hand, parties that were in favor of democratizing the country and other parties that were against. And in the quite traditional Dutch system, the government decided to tackle this polarized issue by appointing a non-partisan committee that was supposed to give an advice on possible constitutional reforms. And this committee, which was actually led by a former prime minister, assessed the 4 different types of referendums that exist. So firstly, we have the rejective referendum, which we call the corrective referendum in the Netherlands, in which the citizens can request a referendum on a new law that has been adopted by parliament, and voters can vote in favor or against the law. This was a referendum time that was supported by the committee. Another possible referendum is the popular initiative, in which citizens can propose their own proposal for a law or amend a law, which is then submitted to a referendum. And then people can vote in favor of the popular initiative or against it. This was actually also supported by the committee, but just by a majority. Then there are 2 additional types of referendums. The mandatory referendum, in which the law requires that a referendum is held about a topic before it can be passed, for example, about the constitution. And there is also the consultative top-down referendum. And in this final type, parliament or the government submits a proposal of its own to a referendum, and the citizens can vote upon it, but the outcome is not binding. And this final type of referendum was opposed by the committee. So we have this advice of this non-partisan committee. Didn't really alter the political positions that much. The parties that used to be positive about more direct democracy remained in favor, and the parties that were already skeptical remained skeptical. So we start to see a divide between the left and the right. So basically the progressive parties, social democrats, socialists, Greens, were in favor of the rejective referendum, and the Christian parties and the conservative liberals were against the referendum. And I will now give you an overview of how support for the referendum changed. In this graph, we can see from the 70s to the start of the 20s how many seats in the Dutch parliament are in favor of the rejective referendum. The red line visualizes the support, the parties that are against the referendum, and the green line, the ones that are in favor. In the Netherlands, for a constitutional amendment, it's necessary to have 2/3 majority. And this is also shown in the graph with the black line. And it's visible in the graph. There was no majority at that time for a rejective referendum. Not a 2/3 majority, and also not an ordinary majority. But over time, this changed. In the 19s, the support for the referendum gained momentum. On the one hand, the Christian Democratic Party, which was the primary opponent of the referendum, had a historical defeat in 1994, whereas the pro-democracy Democratic Reform Party, D66, gained its best result in history. And this led to a new coalition, a coalition without Christian Democratic parties, but a coalition between progressive parties and the conservative liberal parties. And in this coalition, it was agreed that the new government was going to introduce a binding rejective referendum. The conservative liberals agreed with this in exchange for neoliberal reforms in the economy. So this government also did in fact try to introduce the the referendum by submitting a constitutional amendment. And this went to a second reading, and only at the final moment, which is quite notorious, the one single senator from the conservative liberals defected from the party stance and the coalition agreements and voted against the constitutional amendments, and his vote was the deciding vote. So the constitutional amendment failed to pass just by one vote. Because it was against the coalition agreement, of course, the other parties in the coalition were very unhappy about this and received compensation from the conservative liberals, namely the introduction of a temporary consultative referendum in 2001. And this referendum existed for 4 years, but it was not yet used. And quite quickly after its introduction, the wind changed, because the opponents of the referendum, especially the Christian Democrats, researched in the 2000s, the early 2000s. And this meant that there was no longer a majority for the referendum, and it was abolished. But this was not forever, because in the mid-2000s, just like in many other European countries, we saw the emergence of radical right parties in the Netherlands. So the Freedom Party of Geert Wilders was established in 2006, and it gained quite a lot of seats for a new party in the Dutch parliament. And interestingly, unlike the other right-wing parties, the Freedom Party is at that time, the only right-wing party that did support the introduction of the referendum. And this meant that the support again for the referendum increased, and that the left-wing parties were able, with the support of the Freedom Party, to pass a quite ambitious referendum package in 2015. And this package consisted of a consultative rejective referendum, so it was not binding, but it was quite ambitious. So citizens were able to request a referendum on almost all topics, with just 300,000 signatures, which is 2.5% of the population. And as I mentioned, only few topics were excluded. So only the monarchy, the budget, and constitutional changes were excluded. This referendum design also furthermore included an outcome threshold. So a referendum under this law was only valid if it did pass the 30% turnout threshold. Otherwise, the results were invalid. Next to the consultative rejective referendum, the parliament also passed a new amendment for the constitution, in which a binding rejective referendum will be introduced, but this was only the first reading. It needs to be supported in 2 readings, and in the second one by a 2/3 majority. What is important to note, and which is quite interestingly, is that this package was passed whilst a majority in the government was actually against introducing the referendum. So the prime minister and the majority of the ministers were against the referendum package, but nevertheless the left-wing parties, and with the help of the Freedom Party, were able to pass it. And this quickly led to the first experience in the Netherlands in modern times, with the rejective referendum, because only 2 days after the law was passed, Eurosceptic activists immediately wanted to use the referendum. Their preference was to have a referendum on EU membership of the Netherlands, but that was not possible in this type of referendum, because you can only request a referendum about a law or a treaty that has been recently passed by the parliament. So instead, they decided to just request a referendum on the first Europe-related topic that was passed by the parliament, and that happened to be the association agreement between the European Union and Ukraine. Slightly wrong. It has to say European Union and Ukraine. And the referendum campaign was really framed by the organizers as a vote upon EU membership. And this became so notorious in one interview that two of the organizers mentioned that they actually didn't care about the topic of the referendum and that it was all about European Union membership. It will be noted that this only reflected the perspective and opinion of some of the organizers and not all of them, but still. And that from election research, we also know that a majority of the voters that opposed the treaty actually did oppose the treaty because of substantial reasons. But it did set the tone for the debate. And the campaign that followed was quite one-sided because the parties that were in favor of the treaty did barely campaign in favor. The hopes that the turnout would be below the 30% threshold because then they would also win. And so most of the parties in favor did not campaign. And some politicians and pundits even called for a boycott. Whereas Eurosceptics from both the left and the right fiercely and massively campaigned against the treaty, and this led to the result that 2/3 of the voters voted against the treaty in the referendum, and only a 1/3 in favor. In the end, the referendum turnout was just above the 30%, and that meant that it was valid. But the government decided to ignore the referendum outcome and ratify the association agreement anyway. The referendum campaign about the Ukraine referendum was really influential in framing the future referendum debate, especially amongst high educated voters, because due to the experiences during the Ukraine referendum and also the simultaneous Brexit referendum, many voters that are higher educated started to believe that the referendum was just a tool for populists, and that it was not about the substance, but it was just about gut feelings when people were voting. Even though this is actually not correct if you look at the election research. But the fact was that among high educated voters, as you can see in this graph, the support for the referendum dropped from almost 80% to just 50%. While at the same time, the support amongst other education group levels remained constant. And since the high educated citizens are the core electorate of the left-wing parties, this also changed the positions of many of the left-wing parties. Many of the left parties that were always in favor of the referendum did remove the rejective referendum from the manifestos, and we can also see this clearly in the graph that the support in parliament really dropped, just like as under high educated citizens. And this resulted in a very strange situation. So the party that's introduced the constitutional amendment for a binding referendum did no longer support it in the second reading, which created the strange situation that the lawmakers that sponsored it, the parties that sponsored this bill, no longer were going to advocate for it in parliament and voted against it. And at the same time, as I already mentioned in my introduction, the center-right government used this to abolish also the consultative referendum. But this was not the end. Interestingly enough, just before the consultative referendum was abolished, a second referendum was organized. And this referendum was about the authorities of the Secret Service, and was initiated by the progressive left. And the referendum debate was very substantial and in general considered to be really a success. But it was already too late to alter the course that the new government had set, and they went on with abolishing the referendum in July 2018. But also at the same time, the government also had appointed a committee, a non-partisan committee, which was going to come up with proposals to bridge the divisions between society and politics. And this committee, like its predecessors, did advise the government to, in fact, introduce a binding referendum, a binding rejective referendum. And the reason for the primary reason was that this committee really believed that, and I think quite rightly, that there is quite a lot of inequality, political inequality in the Netherlands between citizens with a higher education and a lower education, which can also be seen if you look at the members of parliament. Over 90% of parliament members are higher educated, whereas in society this is just a minority. And this results in that lower educated citizens feel less represented than higher educated citizens. And this is not just an impression. If you look at political science research in the support for laws that are adopted by parliament, we see that in all cases when the preferences between higher educated citizens and lower educated citizens diverge, politicians in the end follow the policies that are supported by the higher educated citizens. And according to a recent study, this has happened all the time, which can be seen in the graph that I'm showing on the slide. The advice of this committee really had an effect again for the support amongst political parties. The left-wing parties that in previous elections had dropped the referendum from their manifesto again started to support the rejective referendum, and also a new center-right party now supports the introduction of the binding rejective referendum, which means that for the first time in Dutch history, both the Dutch lower house and the Dutch Senate support the constitutional amendment by over 2/3 majority. And we don't know how the future will develop, but as of today, it seems quite likely that a constitutional amendment might pass to introduce a binding rejective referendum, which will be relatively similar to the earlier consultative one, but with the change that it does not include a turnout quorum, but will have a more smart quorum in which it's not based on turnout, but on how many people vote against the proposal in the referendum. So to sum up, I think there are a few important lessons that we can learn from the Netherlands. And the first lesson is that referendums can really be a good way to increase the influence of underrepresented groups. For example, citizens with a lower education. But this also means that this will also lead to different outcomes when policies are made. And of course, this is basically in line with what we want from democracy. We want a democratic system to be responsive, but it's not like you can have your cake and eat it. If you give people more influence, that also means that that you can get different outcomes that are more in align with the opinions of marginalized groups or minorities. Secondly, we really see in the Netherlands that referendum design matters. The turnout threshold in the consultative referendum really created quite a lot of problems because there was a strategic incentive for people who are in favor of the treaty to not go out and vote, but stay at home, so the turnout quorum will not be will be passed, and the result will be invalid. And thirdly, the third lesson is, I think, that political parties really have to learn to adapt to the referendum. If you don't campaign, then don't expect to win the referendum. This may sound very obvious, but really one of the experiences in the Netherlands is that parties that are in favor of the topic do not campaign. And it is important in a referendum debate that arguments from both sides are heard. Those are the most important lessons from my side from the Dutch case. And I want to thank you all for your attention.
Thank you very much for your presentation. Now we move to the second presentation. Prof. Claudio, you can continue.
Thank you very much. The Constitution of the Italian Republic is the result of a historical process that led to the end of the fascist regime and the establishment of a democratic system. Fascism had cancelled the role of the representative institutions built by the liberal state and had to replace them with the political powers of the fascism leader. Therefore, it is understandable that the Constituent Assembly placed a great emphasis on the reconstruction of representative democracy, in particular on the strength and centrality of parliament. The parliamentary form of government designed by the Constituent Assembly revolves around the dynamics whose absolute protagonists are the institutional bodies: equal bicameralism, the relationship of confidence between the two chambers and the government, the political function of the parties, the role of the President of the Republic in resolving moments of crisis. Well, in this context, direct democracy could only take on a secondary and complementary role because of in the fear, which was clearly expressed in the work of the Constituent Assembly, that by giving an excessive importance to the direct democracy would risk weakening the delicate mechanism of representative democracy, which instead not only had to be revitalized after the dictatorship, but also to be strengthened within the framework of a mass democracy based on universal suffrage. Despite everything, however, the Constitution houses several institutions of direct democracy, although not all of them with the same degree of importance and effectiveness. But by far the most important institutions of direct democracy provided for by the Italian Constitution are the constitutional referendum and the abrogative or rejective referendum, because they allow voters to cast a decisive vote. Let's start with the former. The Italian Constitutional Charter is rigid because Article 138 provides for an aggregated procedure for the production of constitutional laws and constitutional revisions. Among the elements of aggravation with regard to the procedure for the approval of ordinary laws, we also find the possibility of involving of the popular will. Let's see how. if even only one of the two chambers in its final vote rejects the draft or approves it only by a simple majority, the bill is not approved. If, on the other hand, both houses approve it by a two-thirds majority, the bill is promulgated by the President of the Republic and enters into force. If, on the other hand, the chambers approve it by an absolute majority, but without reaching a qualified majority of the two-thirds, then certain subjects can call for the celebration of a constitutional referendum. These subjects are 500,000 voters, 5 regional councils, 1/5 of the member of a chamber, so 80 deputies or 40 senators. To proceed with the request, all these subjects have 3 months from when the news of the approval of the law has been officially published. On the day of the constitutional referendum, the voter will see in front of his eyes a ballot paper with a question like this. Do you want constitutional law X and Y approved by the Houses of Parliament to enter into force? If the voter is in favor, he votes yes, otherwise he votes no. If the yes vote wins, the constitutional law comes into force. If the no vote wins, the constitutional law is rejected and will never come into force. This is a very important referendum because it allows voters to confirm or cancel the will of Parliament about the constitutional law. Of course, Parliament remains the main protagonist of the procedure described, because if no one of those subjects asks for a referendum, after 3 months, the constitutional law is promulgated by the President of the Republic and enters into force. We are therefore talking about a referendum that is part of a parliamentary procedure, with which it is possible to oppose a deliberation of Parliament before the system is innovated with a new constitutional law. In our political practice, this referendum has been celebrated 4 times. In 2001, the electoral body confirmed the amendment of a part of the Constitution governing territorial autonomies. In 2006, the voters rejected a major reform of the form of government. In 2016, the voters once again rejected another major overhaul of the form of government. In 2020, however, the reform with which Parliament had decided to reduce the number of deputies and senators was confirmed. As it can be seen, this is certainly a crucial example of direct democracy. But it would be a mistake to think that the parties, and therefore ultimately the protagonists of the life of representative institutions, do not have a role in the deliberations of the electoral body. On the contrary, the indications of the parties have always been decisive, both for the yes and for the no, of course, depending on the amount of consensus that each of them achieves among the mass of voters. But perhaps the most important example of direct democracy in the Italian Constitution is the referendum to repeal ordinary law. The Article 75 of our Constitution provides that 500,000 voters or 5 regional councils can request the holding of a referendum to repeal a law that is fully in force in the legal system, no matter if whether it has been for a long time or a short time, if whether approved by the current parliament or by a previous one. What matters is that it is not in the process of being approved, but is already in force. Hence, the abrogative nature of this referendum, unlike the constitutional one we have just analyzed. Therefore, the tenor of the question will be opposite to the constitutional one, namely, do you want the repeal of law X, Y? If the voter is in favor of the law, he will have to vote no. If against, he will have to vote yes. In addition, there is another fundamental difference between the two referendums. In the constitutional one, the percentage of voters reached does not affect the validity of the vote in any way. Instead, the abrogative referendum is only valid if at least half plus one of those entitled to vote participated. That is, all adult citizens who enjoy political rights. Otherwise, it is in Latin, tamquam non esset. The Constitution does not allow referendums to be held on 3 categories of laws: tax and budget laws, amnesty and pardon laws, and authorization to ratify international treaties. A prohibition that touches on different types, but can be traced back to the particular responsibility that representative democracy must take on in fiscal matters, in criminal matters, and with respect to the international relations maintained by our republic. Finally, the last paragraph of Article 75 of the Constitution establishes that a law designs the rules to give concrete implementation to the referendum. However, this law was approved by Parliament only in 1970, and therefore, for a long time, referendums could not be held in Italy. The procedure provides that the promoting committee has 3 months from when it officially files the questions at the competent judicial offices to collect the 500,000 signatures or to have the resolution of the 5 regional councils. Today, the legislation also allows for collection by telematic means. Once this has been achieved, the most important and delicate procedural step is in the review of legitimacy by the Constitutional Court. Having been invested over the decades with hundreds of questions to be judged, the court has produced a vast, rich, very complex, and often discussed jurisprudence, both at the level in terms of legal science and by political actors. In fact, the court, the Constitutional Court, does not limit itself to verifying that the question does not touch one of the excluded matters, but starting from the famous judgment number 16 of 1978, has affirmed that its task is to verify the compatibility of the question with the set of constitutional provisions, not only with Article 75. Therefore, in its copious jurisprudence, it has developed dozens of criteria to verify the admissibility of a referendum. For example, it has ruled out submitting unclear, heterogeneous, ambiguous questions to voters because they do not respect the voters' freedom of choice. For a long time, especially in the past, the rejective referendum has played a very important role in Italian politics, allowing the electoral body to express itself on issues that are particularly felt by public opinion. The first case was an example of this. In 1970, Parliament had approved the law introducing the right of divorce. Subsequently, the Catholic world collected signatures for a question to repeal the law. The Constitutional Court judged it admissible, and so on May 12, 1974, the first abrogative referendum in our history was held, with a clear success for the no to the repeal of the law. Therefore, the political effect produced by that referendum was to demonstrate how Italian society was ready for a season of laws that recognized our other civil rights. For example, reform of family rights, abortion, transsexuality, and so on. Since then, many others were celebrated in very different areas, subjects, including abortion, hunting, economy, electoral laws, and so on. A referendum in 1993 decreed the repeal of the proportional method in the electoral law of the Senate. And since it is possible that the question asks for the total or partial repeal for a law, what remained from the partial repeal of the rules contemplated in the question was the transformation of the law in a majority sense. Those are therefore important and crucial issues for our civil, social, and political life. At a certain point, some political forces and important subjects of Italian social life understood that the rule of the quorum of participation allowed a referendum to fail. Considering that there is a share of about 25% of voters who do not participate in the vote anyway, it is enough to campaign asking one's sympathizer not to participate. In this way, a minority equal to 25-30% of opponents who joins the chronic abstentionists renders the referendum invalid and the law remains in force. This mechanism, together with other problems, has greatly weakened the importance of the abrogative referendum, which for some times has not been able to reach the necessary quorum of participation. To conclude, in my opinion, a constitutional reform would be needed so that, on the one hand, it would increase the number of signatures, even reaching 1 million and more, since it is now possible to collect them digitally. But on the other hand, it would halve the participation quorum in order to diffuse the scope of the political gamble just described. Thank you very much for your attention.
Thank you very much for your presentation. Now we have the third speaker, Prof. Carlos. And please don't forget to ask your questions in the chat. Me and Anya are looking all the time.
Thank you very much. So I am going to share my screen. Yeah, okay. So today I'm going to talk mostly about a very interesting case in Ecuador, South America, about a bottom-up experience of national consultation about oil extraction in a national park in my country. First, well, I would like to present some of the basic facts about which we are going to talk about. A year ago, on August 2023, a national plebiscite on oil extraction in a large oil reserve located in the Yasuni National Park took place in Ecuador. As a result, Ecuador became the first oil exporter developing country to approve, with the support of, in this case, 59% of the population. In Ecuador, voting is mandatory. It is not voluntary. To stop exploiting the oil reserve in order to protect biodiversity and indigenous people rights. This historical decision not only has an important national significance, but also was a very significant global precedent about ways in which the transition away from fossil fuels can take place in order to fulfill the Paris Agreement. I would like first to present some basic traits about the quality of democracy both in Latin America and Ecuador, and in a comparative perspective with Europe. In order to do that, I will use the economist intelligence unit democracy index, it runs between 0 and 10 points. The average index was 7.5 in Europe, 6.5 in South America, and only 5.9 in Ecuador. So actually the quality of democracy in Latin America in general, and particularly in Ecuador, is substantially lower than that compared with Europe. In this rather adverse context of an imperfect or weak way of ruling of law, it is very significant that a successful bottom-up approach initiative, which led to a national plebiscite on oil extraction in Amazon, which is a very, very significant topic in the case of Ecuador, because oil is an oil-dependent country, was able to happen. This was the result, actually, of a decade-long legal and social struggle to preserve the Yasuni National Park and one of the most biodiverse hotspots in the Western Hemisphere. Well, what I'm going to do in this presentation mostly is to present the context of the plebiscite and to try to make an important analysis about the lack of fulfillment of the results so far and the prospects for the future. First, using the mentioned index, we can see very clearly that not only democracy, the quality of democracy in Ecuador is weak, as I mentioned, but also that in the last 6 years, at least from 1918 to present, it is strongly declining. So Ecuador is affected. That it seems to be a problem that's happening worldwide. The quality of democratic institutions is deteriorating in most of the countries of the world, but this is particularly severe in the case of Ecuador. Here we can continue seeing this chart, but compared with the average Latin American democracy index, in which we have the same structure. That means that not only is weak, but also has been declining strongly from 2018 onwards. And here we have finally a comparison with Europe. The highest scores are in Europe. Actually, in the European context, also we have some degree of declining equality of democracy. The second line presents the case of South America, and finally, the situation in Ecuador. So we have an international and national context of declining rule of law in general, particularly in the case of Ecuador. Here we have some of the reasons because this is happening, the lack of transparency. In the political institutions, I am using the Transparency International score. In the case of Ecuador, for the last years, actually Ecuador is ranking very, very low in the international context, as you can see here, in a position 115 among 180 countries, taking into account the degree of transparency, of the perception of transparency among the public institutions. Well, going more specifically to the point, it's very important to set up a background. First, the Yasuni National Park is regarded as one of the most biodiverse hotspots in the Western Hemisphere. There is a lot of scientific information about it, and also is the home of the two only remaining indigenous groups living in voluntary isolation. It's a very large park, it has more than 1 million hectares. Secondly, around 2007, a very large oil reserve was confirmed within the park in the ITT field. In 2007, the government decided to present to the international community the Yasuni ITT initiative, which was a very interesting proposal with the support from the UN to leave all the reserves in the field unexploited if an international compensation fund can be reached to compensate the country for the lack of oil revenue. 6 years later, the government canceled the initiative and opted to begin extracting the oil. It was a very unpopular decision, actually, at that moment. And a few months later, a very, very powerful and unexpected social movement, mostly a young social movement, emerged. The name is Yes Unidos. And Yes Unidos was able to collect about 750,000 signatures, which are more than 5% of the electorate, asking for a national plebiscite about oil extraction. It happened in 2013. But next year, the government illegally and with a fraudulent decision denied the constitutional right to the plebiscite, arguing that the signatures were invalid. So Yes Unidos decided to begin a very, very difficult and long legal conflict with the government. And finally, 10 years later, in 2000, actually, there's a mistake here. In 2023, last year, the Ecuadorian Constitutional Court decided to recognize the signatures and asked for a national plebiscite. The plebiscite, as mentioned, took place on August 20, and 59%, which is a very solid majority, of the Ecuadorians decided to close oil extraction in the field in order to protect biodiversity and indigenous people rights, and within a 1-year period. However, the government did not close the field. That is very important. We have more than, the plebiscite took place more than a year ago. So according with the resolution, the field must have been closed. However, it didn't do in that way. Actually, very little reduction in production is taking place, and the government instead is proposing a 5-year period of progressive closing. The legal and environmental problems persist because of the lack of adequate fulfillment of the plebiscite. Here, I am going to present some very, very important facts about what happened in the plebiscite. First, here we have a map of Ecuador, and the yellow and green colors means regions where the plebiscite was won. And actually, in 22 of the 24 Ecuadorian provinces, the plebiscite was won. So the support for closing the oil field was extremely high and homogeneous along with the country. Analyzing both electoral results and some opinion polls, it is very interesting to find that the support for closing the oil was very homogeneous among educational level, age, and socioeconomic status. But I am going to present some very interesting difference. The support was highest, first among women. That's very interesting. Secondly, among young voters. And finally, among people with mid or high educational levels. In the case of indigenous peoples in Ecuador, actually, they were deeply divided, but the majority of the indigenous population actually supported the stopping oil extraction. However, in areas very close to the oil fields, the fear of losing the job for people linked with the oil industry had an impact, so that in that area, the plebiscite was lost. It was the two only provinces where the plebiscite was lost. Another case of a lost plebiscite took place among very high income groups who actually opposed the closing the field. it is very interesting to analyze the electoral campaign. First, it was a very unequal campaign because with the support of the government, the active support of the government, which is actually illegal but happened, the support from obviously oil companies and conservative groups, a very well-funded electoral campaign against closing the oil field took place. This was mostly concentrated on media, particularly TV, radio, and conventional press. The social group, Yas Unidos, and grassroots organization jointly did their own campaign, but in that case, as they lacked funds, this campaign was mostly done using electronic social networks, such as TikTok or YouTube and so on, with very low economic resources, but very sophisticated, because of education, technical skills. So the campaign for closing the oil field actually have a very limited access to conventional media. So it was very interesting, the case in which a grassroots movement, relatively loose, but very well dotated of technical skills, was able to win over a very well-financed campaign promoted by oil companies. We have analyzed several opinion polls that took place, particularly in last year, and we can see several common traits. First, the public opinion in Ecuador is very critical about the social and environmental effects of oil extraction in the Amazon. First, they perceive strong negative impacts of oil extraction and environmental effects on public health, particularly among indigenous peoples, lack of oil contribution to social development, and there is also a widespread perception of corruption and mismanagement among oil companies. So this is the context about the plebiscite. I am going to briefly refer also to what happened after the plebiscite. According to Ecuadorian constitution and law, the results of a plebiscite, of a national plebiscite, must be fulfilled and enforced in a mandatory and immediate way. Actually, the resolution, according with the law, has to be implemented in 1 year. However, after a year of the plebiscite, the government neither stopped oil extraction in the ITT field nor applied environmental remediation. So actually, the government did not fulfill or very barely fulfill the results of the referendum. Only a weak 5-year plan was presented, and it's being applied by the government, and they say that they will progressively close the field in a 5-year period, arguing technical limitations. Actually, oil extraction already declined by 20%, but they must be closed. So it's a big difference. So this illegal outcome reveals the weakness of the rule of law in Ecuador. There is a conflict between a powerful social mobilization capability of environmental and indigenous movements and the strong political support from the highest echelons of the dominant class, and particularly oil-linked interests. That is the situation now. So thank you very much for your attention, and I am very glad to continue responding any questions you may have.
Thank you very much. Thank you very much to 3 of speakers. very insightful presentations. I see that we have a question in chat. In any case, please raise your hand. The question is from Frida, and it's, I have a question regarding the referendum in the Netherlands. It was mentioned that it could affect the outcome of policies, etc., when including the lower educated through the use of referendums. So what kind of consequences could one expect? For instance, could it affect the campaign from politicians, voting turnout in general?
Thank you very much, Frida, for the question. If you look at the political preferences of citizens with lower education compared to higher education, there are some clear divergences. So if you look at those preferences, citizens with lower education generally tend to be a bit more left on socioeconomic issues like healthcare, but more conservative on issues like law and order, on migration, on European integration. So if you have a referendum, I should stress this is based on research in the Netherlands, so I'm not sure to what extent it does translate to other countries, but if you look at the case of the Netherlands, then it will be likely that having a referendum or a popular initiative will eventually result in that policies is shifted more towards, on the one hand, a more left-wing policy on the economy, and more conservative right-wing policies on the other three issues I mentioned: law and order, migration, European integration. I'm not so sure about if it will also affect turnout for elections or referendums. Yeah, that's in the. I don't think there were, of course, some patterns in the two referendums we had in the Netherlands, but I don't think that's enough to make really strong conclusions about it, especially because the turnout was probably a bit weird because of the turnout quorum. I hope this answers your question.
Yes, thank you very much. Maybe some other speakers. Claudia, Carlos wants to add something on the topic, not necessarily the Netherlands, but just in general, yeah. Do you want to add something? If no, I think we have another question from Lorenza. I have a question on Ecuador. What are the other practices of direct democracy in Ecuador, like petitions, citizen assemblies, other mechanisms, or also maybe other direct democracy tools? And Carlos, while you answer, I'm just reminding all of the other participants that if you have a question, you can write it in chat or raise your hand, and we'll then allow you to speak and ask your question directly. Thank you.
Okay. Regarding other ways of practicing direct democracy in Ecuador, we have had in the last 20 years a very high numbers of referendums and plebiscites. But I was referring to this particular case of oil extraction because it's the most significant direct example of bottom-up democracy. However, in most of the remaining cases, we have plebiscites that were presented mostly by the government, according with the, for example, we have a new constitution in Ecuador, which was created in 2008. It was very important because it's the first one to include the recognitions of rights for nature, another very important and progressive environmental and social advances. It was approved by a national referendum with the support of more than 70% of the population. And then I think almost every year ever since, the government has presented a very long series of questions to the electorate. However, this kind of referendums, the last one took place in April this year, are not quite effective because usually people understand them as a referendum about the government itself. Sometimes the questions are quite sophisticated and difficult to understand. So people just vote in favor or against the government. For example, President Lasso, the former president, presented a national referendum with about 11 questions, very difficult to understand. And in spite of in some cases, the support for the legal change was rather obvious, the government lose all the 11 questions because people understood the referendum as a kind of support or rejection to the government itself, not about the specifically designed questions for the referendum. So this happened several times in Ecuador. It didn't happen actually last time because we have a very serious expansion of violence in Ecuador, and the government also decided to present a referendum about expanding the powers of the police and the armed forces to combat narcotic smuggling in the country, and the government won in that case in most of the questions. So in that case, actually, the people actually differentiated between different questions, and the results were mixed. Some social changes in the labor market, for example, were not approved, but questions about reinforcing the capability of the government to combat violence were accepted by a big majority of the population. So we have a long experience of direct consulting coming from the government in the case of Ecuador. But the case of the Yasuni was very interesting because it was actually a bottom-up experience, completely different from that of this continuous set of cases about direct democracy proposed by the government.
We have another question for Ecuador. What are the reasons why the citizen initiative right in Ecuador national was just once in the case you presented? From Klaus Hoffman. You have it, yeah, on the side.
Well, actually, it was used only once because of the very strong obstacles or hindrance for actually a direct participation of grassroots organization in the country. As I told you, generally in Latin America, democracy is weak. We have frequent human rights violations. We have criminalization of social activists. We have limits of freedom of speech in some cases in Ecuador, and so on. The political institutionality of political parties is extremely weak. So we have a kind of imperfect democracy. But at the same time, as most Latin American countries have experienced a very deep social crisis, social mobilization is strong. So this case is a particular interesting case because of the positive result of a 10-year-long legal struggle that ended with the support from the Constitutional Court in Ecuador. So this, in my opinion, is an exceptional case. but it is very interesting because it's the first time that actually grassroots organizations, which have a powerful capacity of social mobilization, also were able to win a legal case. And also, they won the referendum. So it was a very, very interesting case for both results.
Thank you very much for both of your answers. Maybe I have another question if someone doesn't want to speak. Okay, so my question is for Professor Claudio and is about what are some of the opportunities or limitation you foresee in the implementation of Article 75, as you mentioned before?
You refer to my idea of eventually constitutional reform to revitalize this. But this is a great problem in this moment, and not only in this moment, for a lot of years in our political constitutional life, because of this gamble is very used by a lot of political and social subjects. And it is a very bad gamble because in our political life, we have, in our political history, we have a strange relation with the participation to the political institutions. Because for a lot of years, when there are the classical parties of our history, the participation to the general elections and to the regional or local elections in by our electoral body was very high, plus than 90%. The most important participation in Western Europe. But when the political system has changed in the last years of the 20th century, the participation began to more and more decrease in our praxis. So when political parties and social subjects understood this trend, they thought if there are a lot of more and more chronic abstentionists, we could fail a referendum, only join a very small minority to achieve the 50 plus 1%. So if we want to revitalize this institution, in my opinion, it would be important to give a sort of trade-off between signatures, because 500,000 signatures was a number fixed in another time. In this moment, it's not a great number of signatures, especially with the possibility to use digitally tools. So it would be logic, in my opinion, to increase the number of signatures, 1 million, 1.5 million, and so on, but at the same time to lower the threshold of the turnout to consider valid this referendum. In my opinion, 20 or 25%. So with this threshold, we have the double advantage to give a valid critical mass for the referendum. But it would be impossible or tendentially impossible to make the gamble. But it is only my opinion. Such a similar opinion some months ago was expressed by the president of our constitutional court, that it is only also my colleague, my very distinguished colleague. So that opinion is very much more important than than one expressed by me, of course. So, but in this moment, there's not in Parliament scheduled a procedure about this hypothetical constitutional reform. Thank you very much.
Thank you very much for your answer, and thank you very much to all of you for joining us today. A big thank you to the speakers. I think it was a very thoughtful webinar. And before closing, I just want to mention one more time that on the 24th, we have another webinar on a small state island. So please join. I hope you have a good evening and rest of the weekend. Thank you for joining one more time. And maybe Anya wants to say something.
Yes, no, exactly. Thank you very much. And I'm very happy to also see here people who are not joining us for the first time, but actually several times in a row. So I'm really hoping to see you on our next webinars. Thank you very much to our speakers. I'm incredibly grateful for your inputs and for you being here. And yeah, hopefully we'll see each other soon. And yeah, have a nice evening. Thank you very much.